I sued a fast food chain for $2 million because my sandwich didn't look like the picture. I saw the billboard on my way to work. A new chicken sandwich from Burger Barn, stacked 6 inches high, with crispy golden chicken, fresh lettuce, thick tomato slices, and what looked like artisan mayo dripping down the side. The photo made it look like something from a cooking magazine. My stomach growled. I pulled into the drive-thru the next day. What came through the window was not what was on that billboard. It was flat, lukewarm, and the lettuce was a single translucent leaf that looked like it had given up on life. The chicken patty was the size of a hockey puck and roughly the same texture. I sat in the parking lot and looked at it. Then I looked up at the billboard towering above the restaurant. Same sandwich, completely different reality. I posted about it online that night. Photo of the billboard next to a photo of the actual sandwich, side by side. The post got 3,000 likes in 2 days, which was roughly 3,000 more likes than anything I'd ever posted before. People were angry. Comments poured in. Everyone had a story about food that didn't match the ad. Someone in the comments said I should sue. I laughed it off. Then someone else said it. Then 12 more people. Then a guy who said he was a lawyer messaged me and said he'd been looking for exactly this kind of case. His name was Brett Fulgham. That should have been my first warning sign. Brett ran a one-man law practice out of a co-working space. He wore sneakers to our first meeting and had business cards that said "Disrupting Justice" under his name. He was 28 years old and had passed the bar 11 months earlier. He was, in retrospect, exactly the wrong person to take this case. But his pitch was convincing. He said food advertising fraud was an emerging area of consumer protection law. He said several class action suits had been filed against major chains for misleading food photos. He said we could seek $2 million, compensatory and punitive, and that the viral post proved public harm. I believed him because I wanted to believe him. Brett filed a 16-page complaint against Burger Barn Corporation alleging deceptive trade practices, false advertising, consumer fraud, and, I wish I was making this up, intentional infliction of emotional distress over a chicken sandwich. He included my side-by-side photos as Exhibit A and screenshots of the viral post's comments as evidence of widespread consumer harm. The story got picked up immediately. Not by legal publications, by comedy websites. Late-night shows did bits about it. I went from guy with a funny post to guy suing for $2 million over a sandwich overnight. My mother called and asked if I'd lost my mind. I told her this was serious. She said, in a way that suggested she disagreed. Burger Barn's response was disproportionate and immediate. They didn't send a local defense attorney. They sent a partner from one of the largest food industry law firms in the country. A woman named Patricia Sinclair, whose client list included half the Fortune 500 food companies. She flew in from Chicago for the motion hearing. Her motion to dismiss was 41 pages long and cited 37 cases. Brett's response was 8 pages and cited 4. When I saw the two documents side by side on his desk, I felt the same sinking feeling I'd had looking at the billboard versus the sandwich, promises versus reality. Judge Martha Halperin didn't hide her skepticism. During the motion hearing, she asked Brett to explain specifically what damages I had suffered. Brett said I'd paid $8.99 for a product that was materially different from its advertisement. The judge looked at him over her glasses and said, $8.99. And you're seeking $2 million. Brett started talking about punitive damages and deterrence and consumer protection principles. The judge let him finish. Then she asked, Mr. Fulgham, did your client eat the sandwich? Brett paused. Yes, Your Honor. Did it make him ill? No, Your Honor. Was it food? Technically, yes. The judge did not. Patricia's argument was surgical. She said that food photography is universally understood to be stylized. That no reasonable consumer expects a fast food sandwich to look identical to a billboard. That the FTC's own guidelines distinguish between aspirational advertising and material misrepresentation. That I ate the sandwich without complaint at the time and only filed suit after a viral post attracted attention. She said the emotional distress claim was, and she paused here, choosing her words, perhaps the most creative application of that cause of action I've encountered in 23 years of practice. The judge's mouth twitched. Brett objected. The judge overruled him without looking up. The judge dismissed the case with prejudice, meaning we couldn't refile. In her written opinion, which she clearly enjoyed writing, she noted that while food advertising practices may warrant scrutiny, the appropriate remedy was a refund request or a complaint to consumer protection agencies, not a $2 million lawsuit. She wrote that the emotional distress claim strains the bounds of legal creativity and that case was not a serious use of this court's time. Brett told me we could appeal. I looked at him, really looked at him, maybe for the first time, and said no. I'd become a national punchline over a chicken sandwich, and I wanted it to stop. 3 weeks later, Patricia Sinclair filed a motion for attorney's fees under the state's frivolous litigation statute. The judge granted it. Burger Barn's legal bill for defending this case came to $31,000. I was ordered to pay it. $31,000. That's roughly 3,445 Burger Barn chicken sandwiches, if you're counting. Brett had taken the case on contingency, so I didn't owe him anything. Small comfort. When I now owed a fast food corporation more money than I made in 6 months, my mother called again. This time, she didn't say, She said something worse. I told you so. She was right. She always is. I drive past that Burger Barn every day on my way to work. The billboard is still there. Same sandwich, same impossible stack of fresh ingredients, same artisan mayo. I don't look at it anymore. I've set up a payment plan for the $31,000, $650 a month for 4 years. Every month when I write that check, I think about the $8 sandwich that cost me $31,000. People still recognize me sometimes. Hey, aren't you the sandwich guy? I just nod and keep walking. Brett Fulgham's website now says he specializes in cryptocurrency law. I hope his crypto clients have better luck than I did. The sandwich, for the record, was mediocre. Not worth $8. Definitely not worth $2 million. And absolutely not worth $31,000. Was suing for $2 million justified over a sandwich?